Hi, Miguel. I see you just joined us. Can we do a quick mic check?
Sure. Hi, good morning. Can you hear me?
Yes, indeed. Thank you very much.
Terrific. Thank you.
Colin, this is Danielle. I'm sorry to throw this wrench at you, but Steve Preminger is unable to find this meeting being broadcast on the county's website.
Oh, I don't think it's live yet, but I will email him the link.
Okay, that would be fabulous. Thank you very much.
And Danielle, I believe the meeting is now live on the web, so he should be able to see the stream momentarily. Good morning. This is a courtesy announcement that the meeting is now live on the web. Thank you. Good morning, Dr. Smith. I see you've just joined us. Can we do a mic check, please?
Yeah, I'm here. Can you hear me?
Yes, loud and clear. Thank you.
Thanks, Frank.
Good morning, Supervisor Smitty. I see you just joined us, as well as Supervisor Cortese.
Thanks so much. Is that you, Frank?
Yes, this is Frank. I'll be the clerk for today.
Thank you for your assistance today. And let me see if we can, there we go. I see Supervisor Cortese at the ready. Thank you. All right. Then let's go right ahead and call the meeting to order. This is our October 7th regularly scheduled meeting of the Federal Affairs Advocacy Task Force. First item of business is to call the meeting to order and establish the presence of a quorum. So let's turn to the clerk to call the roll, which should be a brief affair since there are only two members of the task force.
Vice Chairperson Cortese.
Here.
And Chairperson Smitty.
Present. Thank you very much. A quorum has been established. Takes public comment. Public comment is that portion of our agenda set aside for comment on non-agendized items that are properly within the sphere of the committee. So let me ask the clerk if there are any members of the public who would like to speak, and if so, we will allow them up to 3 minutes.
We currently have one speaker in queue. The next speaker is B. Beekman. I am unmuting you. Please accept the unmute and you'll have 3 minutes to speak. The timer will start when you begin speaking.
Hi, Blair Beekman. Thank you for the meeting today, and thank you for allowing 3 minutes of public comment. In my last public comment of the day at the BOS meeting yesterday about COVID-19, I should have included that if we all make the efforts and demands, a COVID-19 vaccination can be more fully ready for US public distribution by late January 2021. A reminder to please be wary with your decisions yesterday. Please be wary and be careful that COVID-19 cases have been on the rise in both New York and LA. In this time of COVID-19, I hope we can work, we can see the work of other cities and counties around the Bay Area and around the country and take to heart what is possible to work towards at this time. You know, when you see the good work that other cities and counties do, I hope we don't feel fearful that, and we can emulate that work and we can copy it. And it's important to see good examples at this time and really know how to then use them. So good luck in those efforts. I've described my feelings, you know, that we really have to expand 3088 and really look for how to expand that and look for the good ideas that are totally there for us, how to do that. Ashkara has a really good mind in how that can work, and he should be really trusted at this time. And to conclude, you know, you had a lot of effort towards fire issues yesterday and consolidation, and thank you for your efforts. You know, it's really tiring, and I come from the position where I want to consider what exactly are good, better bureaucratic practices to prevent, you know, the fires from happening in the first place. I have a minute left. So, you know, in places like Santa Rosa, they're going through a lot right now. And how can we get to a position in Santa Clara County to just prevent and prepare those fires, you know, from not happening in the first place? And, you know, I'm a bit worried or questioning that, you know, you're using a sense of austerity to try to address future fire issues by consolidating. But where the austerity needs to be and the consolidating needs to be is in the bureaucratic realm that can just simply prepare what to expect in our future lives and to take the steps accordingly that prevent the harm to mass numbers of people. And that's a real effort we all have to consider at this time, and how to undertake that, to use the word undertake, but, you know, just how do we prepare ourselves for that? And it's a difficult thing. I hope we can at least be thinking about it. Thank you.
This concludes the public speakers, Mr. Chair.
Thank you very much. That takes us to item number 3, which is the consent calendar, and also any changes to our agenda today. I will ask Supervisor Cortese if he's prepared to move the consent calendar as contained in our published agenda. And also note, Supervisor, my understanding is you have a memorial service that requires you to step away at 10:30. So I just wanted to flag that and say thank you for making the effort to be with us as long as you can this morning.
I appreciate acknowledging that, and also letting the public know I'm supposed to be at the site of the funeral at 11 o'clock. So I am happy to make the motion to approve the consent calendar at this time.
All right, thank you very much. Mr. Clerk, you want to call the roll just for the record, please?
Certainly. Vice Chairperson Cortese
Aye.
and Chairperson Simidian.
Aye. Consent calendar is approved. That takes us to verbal reports from the chair and the vice chair. None to offer this morning. Supervisor Cortese, I know you had
My
raised.
apologies, Mr. Chair.
Yes.
We had a hand up for the consent calendar public comment portion.
Thank you. Mr. Beekman is Mr. Beekman our next speaker, please?
Yes, Blair Beekman.
Mr. Beekman, I'm just going to ask you as a courtesy to the committee and to the public if you could forego comment today on a non-substantive consent calendar. Is that okay? We're tight on time with Mr. Cortese.
Looks like he lowered his hand. Thank you very much, Mr. Chair.
And thank you, Mr. Beekman. I appreciate your courtesy, understanding our time constraints. That takes us to the verbal reports from the chair and the vice chair. Nothing to report from me, but I did think it might be useful, Mr. Cortese, Supervisor Cortese, if you reiterated the issue that you were hoping we would spend some time on today, which you referenced yesterday at our board meeting, so that even if you have to step away, we do have that conversation today. I wanted to accommodate that if we could.
Well, thank you for that. I'm really just asking that on the prior discussion we had, it might have been a couple of meetings back, where we had some advocates here, including some from Silicon Valley Debug, I believe. There was a request that County Council would look at whether or not it's possible to replicate the House resolution this is separate from the HEROES Act, but the House resolution that would provide some tenant assistance. And I believe that County Council actually took a look at that in a privileged manner, and also may have spoken to some of the advocates directly, but I was just asking that we get a public off-agenda report that could be shared by your office and mine, and frankly, any of the supervisors, if that question comes up again. It's tough to answer the question, as you know, when you get a constituent email following a meeting, and it's it's cloaked in privilege, at least what we have at this time. So just a simple request for a public version of that response. I thought it was HR 6615, but to Mr. Mitra, excuse me, I think you know which House resolution I'm talking about. And if that's the incorrect number, I trust that you'll find the right one. Thank you.
I will, and we will follow up. Thank you.
Thank you, Supervisor Cortese, and I'll try and follow up on that when we get to County Council's report here in a few minutes. No other reports. So without objection and hearing none, the chair and vice chair's verbal reports will be deemed accepted. And then we have item number 5, which is the CEO verbal report. I'll turn to either Dr. Smith or Mr. Marquez for that. I do believe one or the other is with us and can give us the initial report. And after the initial report, we'll see if there are members of the public who wish to speak.
Yes, Supervisor, I think Danielle Christian is going to give us a little update about recent activities in Washington and Sacramento.
Thank you very much. Ms. Christian?
Morning, Supervisor Simidian and Supervisor Cortese. I'm going to provide just a very quick update because most of the important updates are going to be provided in agenda items later on down the list. I would say, one of the most significant things that's been hitting the news lately, and it's not a surprise to anyone, is President Trump has tested positive for coronavirus. More than 20 people around and working inside the White House have also tested positive. The effect is really more political and on his campaign. At the current time, he's unable to attend rallies, unable to attend fundraisers. He has tweeted that he still plans to debate next week, but whether or not that occurs is yet to be seen. The impact all of this is really also yet to be seen, but it has been in the news, so I did want to raise it. The other item is yesterday, the Trump administration announced rules that will limit the use of H-1B visas, which are intended for jobs that require specialized skills. These visas are widely used by many tech firms in the Bay Area. The rule will go into effect 60 days after publication in the Federal Register. And it's likely to be challenged in court, and we'll see where that goes, but it's another indication and action of the Trump administration's efforts to curb immigration into the country. And with that, I'm happy to answer any questions. As I did mention, there are a few other updates on a federal COVID stimulus package that will be provided on your last item on the agenda, an update on budget activities, and a health update. I think the more salient items will be covered in those agenda items.
Thank you, Ms. Christian. Let me turn to Supervisor Cortese, see if he has any comments or questions in respect to the report.
Nothing further, thank you.
Nor do I. Let me check with the clerk and see if we have speakers on this item.
We have one speaker in queue, Mr. Chair.
Thank you. If we could ask that speaker to go ahead and share his or her comments, and as you can see, we allow 2 minutes for comments. Thank you.
The next speaker is B. Beekman. I am unmuting you. Please accept the unmute and you'll have 2 minutes to speak. The timer will start when you begin speaking.
Hi, thank you. You know, I was trying to find a way to wrap up my public comment. Thank you. And I just wanted to say that, you know, it's a concept that is a concept, and I just hope we can think about it as a whole, as a community and as a county. As county workers, I hope we can just think about the issue and what can be choices and how to, you know, consider healing. And so, thank you. This time of COVID-19 will hopefully be only for another year and a half. Recently approved California State AB 3088 can only function with much action and work at the local level. A thank you to the current help from the City of San Jose and the VTA with local small businesses. David Chu, Ashikawa, and other assembly persons of the SF Bay Area worked much this past summer to create a simple funding system where owners could be offered a guarantee on their mortgages and bills. From this, tenants would not have to be harassed or sued, and would also be offered their own rights and guarantees. This would be a plan available to owners and renters alike of small businesses and apartment dwellings. From the meaningful work of assembly persons this past summer, I hope we can all make the efforts to expand the ideas and purposes of AB 3088 this fall. Thank you. Thank you for your work.
Thank you very much. And on that, we can turn back to Dr. Smith, see if there's anything else for the CEO's verbal report before we go on to County Council.
No, I have nothing else to say at this point. When it comes to the discussion about the HEROES Act failure, I'd like to say something.
All right. Then for the moment, without objection and hearing none, we'll consider the report received. And for the clerk, I'm going to take the view that on simple receipt of a report, we need no roll call, just for the record. And then that does take us to item number 6, which is the County Council's report. And I think both Mr. Mitra and Mr. Press are standing by, and forgive me if there's someone else on the screen that I can't see. Why don't we go ahead and ask you for your, any update you'd like to provide. We did, just for members of the public and staff who are not aware, we did ask for specific updates on this issue of rent abatement or renter relief that Supervisor Cortese referenced, also on any kind of foreclosure forbearance. And then the other item was the issue of serve justice versus Devos, which is an issue that was raised at our board meeting a couple of weeks back, which we asked to get a report on. We did note that the county has been monitoring the case and wanted to get an update. So with that, those and anything else County Council would like to lean in on, who'd like to begin for County Council?
Good morning. This is Douglas Press. Good morning, supervisors. So 3 issues. One is I wanted to provide a brief grid update just on 3 matters in particular from the grid that's part of your packet. And then also to address your 2 matters, the rent abatement, eviction moratoria, and then an update to the serve justice and unrelated lawsuits. In order to accommodate Supervisor Cortese's schedule this morning, I leave it to you as to which one of those you would like to take first. I don't know if you want to hear about rent abatement first, or if you want to hear about the grid update and serve justice first. So I leave that to you.
Supervisor Cortese, do you have a preference?
I don't have a strong preference. Beggars can't be choosers, but maybe the rent assistance is a priority. Thank you.
Thank you.
Okay. Then in that case, let me first turn that particular item over to my colleague, Assistant County Counsel Steve Mitra, who is 1,000 times more familiar than I am on the details of that matter.
So, good morning, supervisors. This is Steve Mitra, Assistant County Counsel. A lot has happened at the state level and also at the federal level with regard to rental assistance for tenants. On August 31st, 2020, the governor signed AB 3088, which went into effect the next day, and it essentially set aside a lot of rental payment protections. And what I mean by that is payments, protections for non-payment of rent for folks who were affected by COVID for residential tenants. And it created a whole new regime, which we're frankly still analyzing. But in essence, what it does is converts rent that's due from March 1st, 2020 through January 31st, 2021 to a form of debt, civil debt, that can be collectible in small claims court. Tenants are still obligated to pay rent. They just can't be evicted for it as long as they pay 25% of the rent that's due from September 1st, 2020 through January 31st, 2021. So what happens is the first small claims action that can be brought by landlords to evict tenants for non-payment of rent can only be started on March 1st, 2021. So that's set aside, and the legislation explicitly sets aside vast chunks of the county's protections for residential tenants. Not everything, but most of the county's protection for residential tenants. The AB 3088 legislation does not address commercial small business tenants that the county also protects. And so those continue in effect. And currently, because of the action of the governor's executive order, the commercial protections expire on November 30th. And the board may consider an extension beyond that under the governor's executive order. And I presume we'll be doing that shortly. So we've got 2 tracks: the commercial tenants, which the county can protect and does protect, and residential tenants, which are now mostly protected under state law. There was also a CDC order, which applied to tenants within certain income groups who might be rendered homeless because of the conditions related to the pandemic. But that only applies in situations where the local jurisdictions have not enacted protections that are more, that would lead to better public health outcomes. And the consensus view appears to be that AB 3088 is pretty strong. And so that is the operative, that provides the operative set of rules in the state and then flowing down to the county. I'm happy to answer more questions. And in terms of Supervisor Cortese's request to have a public memo on rent abatement and what we can and can't do, I will take that back, but obviously we will do what we can to provide that to you.
Thank you, Mr. Mitra. Supervisor Cortese, in deference to your time constraints, I want to turn to you first for comments or questions on that issue in particular.
I appreciate the overview, very clear and consistent with what I thought I heard in the past. And I also appreciate the additional response on getting the public memo out. Thank you.
Thank you. Mr. Mitra, could you give us some kind of a timeline on that public memo, just a process so that we don't have to keep checking in with you, but can let you go off and do your work with some certainty about a timeline?
So just to be clear, this is a public memo on the rent abatement steps that the county can take that housing tenant advocates want. I'd say between 2 and 3 weeks. Would that work for you?
Supervisor Cortese?
Yes, but I just wanted to add, we also would like you to, have some kind of a public response in there in terms of any lingering remaining potential federal action, even if it's, even if it's somewhat unlikely to occur. House resolutions, the lingering possibility of HEROES Act or anything else. I think we just owe it to the public to give them a 1-pager or 2-pager on what we think is out there and what can legally be implemented in short form without getting into the deep dive of legal opinions that you would give to the board, if that makes sense. And I'm happy to have that in 2 different sections, one by legal counsel and one by Danielle Christian in her office, if that makes more sense, so that any attorney-client privilege is protected. I didn't mean to indicate that it had to be 100% coming from county counsel. I just know that you had some involvement with it in the past, Mr. Mitra. So I hope that's clear. Thank you.
Thank you, Supervisor Cortese. I'll coordinate with Daniel Christian and we'll get you something.
All right, thank you very much. Then why don't we return to County Council for an update not only on Serve Justice versus Devos, but other items on our grid, which seems to grow with every passing meeting.
Yes, we're up to 84 pages now. So let me just, and probably growing. So let me just highlight 3. The first, and this appears on page 8 of your packet, this is the National Urban League versus Ross case. This is a challenge to the Census Bureau's plan to shorten its timeline to accomplish, among other things, what is called the non-response follow-up, which is efforts that are undertaken to enumerate populations that are harder to count by the initial and more conventional means. I would note that one of the witnesses in that lawsuit characterized this non-response follow-up as, quote, the most important census operation to ensuring a fair and accurate count. So you've probably been hearing about this lawsuit in the paper recently. This one is being presided over by Judge Koh here in San Jose. We filed an amicus brief in this lawsuit, which is how we expressed our interest. Bottom line is the Census Bureau has been, first, it extended the timelines in which to complete all of these various activities, and then a short while ago, suddenly decided that it wanted to shorten them and go back to a more conventional pre-COVID timeframe, which would have ended data collection on September 30th, as opposed to October 31st, and then would have made the allocation based upon that data collection accomplished by December 31st, as opposed to April 2021. After a TRO and a preliminary injunction that Judge Koh granted on September 24th, those extended dates were restored. So now data collection is supposed to continue to occur through October 31st, and the allocation, or tabulation, I should say, is to be extended to April 2021. The Census Bureau has appealed that matter to the Ninth Circuit Court of Appeals, and they've requested what's called an emergency stay. The Ninth Circuit heard oral argument on that emergency stay just last Monday, and they are reportedly going to issue their opinion on that emergency stay by noon today. And so literally just moments ago, I checked the Ninth Circuit website. That decision has not yet issued, but we clearly will be hearing something about that very, very soon. The next matter, any questions on that, I should say? Any questions?
Supervisor Cortese?
None, thank you.
And none for me, Mr. Press. Thank you for that update. Continue.
Okay, go ahead.
Please go ahead, Mr. Press.
Sure. The second one I wanted to highlight is the public charge rule litigation. This appears on page 16 of your packet. Just to note that, as you may recall, the district court, Northern District Court, issued a preliminary injunction last year barring the federal government from enforcing the public charge rule within California and 3 other Western states. However, the Ninth Circuit stayed the effect of that injunction last December. We just had the oral argument on the merits of that preliminary injunction appeal on September 15th. And Luke Edwards, Deputy County Counsel from our office, led the argument. She did a fantastic job. And so we will learn shortly whether the Ninth Circuit is going to affirm, reverse, or modify that injunction. Any questions about that matter?
None for me. Let me turn to Supervisor Cortese.
None for me, thank you.
Thank you. Go right ahead, Mr. Press.
Sure. The last one from the grid I wanted to focus on is called State of Washington versus Trump. This is one of the Postal Service lawsuits. This appears on page 59 of your packet. We filed an amicus brief in this matter. And this was about the Postal Service's curiously named Leave Mail Behind policy, which entailed the elimination of overtime of Postal Service workers, decommissioning sorting machines, removing mailboxes, things of that sort, changing how mail is classified. On September 17th, the district court, I believe this is up in Washington, entered a nationwide injunction prohibiting the Postal Services from implementing these policy changes. And I just thought it was worth noting that the district court highlighted our amicus brief and mentioned a few of the details that we pointed out that would be potential harms in its decision, including the impacts on collecting fees and taxes, sending pension payments, prescription refills by the mail. So we were definitely heard in that case. I'm still trying to track if that preliminary injunction appeal has yet been filed. Any questions on that?
None for me. Let me turn to Supervisor Cortese.
None for me, thank you, and I'll be departing around now. Thank you.
Okay.
Thank you again.
Right.
All right, so now let me turn to Serve Justice Inc. versus Devos, which is the, I'll just sort of categorize it as the Title IX case.
And Mr. Press, forgive the interruption on this. I know this was of particular interest and importance to Supervisor Cortese as well. And I just want to call out for the record that we are, of course, recording the meeting, and he will have a chance to review the recording. And I know he's got staff who are monitoring this as well. So thank you on both fronts.
Sure. Okay, so to explain where we are in this lawsuit, I need to give a little bit of background on what this lawsuit was about. I will then talk about its current status and then sort of the ramifications of some of the administrative and other legal action that has occurred. So this was a lawsuit filed in 2018 by 3 advocacy groups, and it sought to vacate the federal Department of Education's policy regarding enforcement of Title IX. And this policy enforcement document has come to be known as the 2017 guidance. This 2017 guidance specifically rescinded guidance issued by the same federal Department of Education in 2011 and 2014, where that earlier guidance from 2011 and 2014 was deemed to be much more protective of survivors than this current guidance. And in particular, what the 2017 guidance changed was that it allowed or even obligated schools to disclose the identity of survivors to the accused. It allowed the accused to directly question survivors about the survivor's sexual history. It allowed schools to refuse to investigate off-campus conduct, which was a change, and then also significantly allowed Title IX investigatory proceedings to go well beyond what used to be the 60-day benchmark for most investigations. There were many, many other changes, but those were some of the more significant ones. So, and I would add, I don't think this is part of the record in the lawsuit, but I have read that in recent years, the number of sexual assault survivors seeking assistance under Title IX has actually dropped by more than a third, with some citing the changes wrought by the 27 guidance in particular. So as you may recall, the Serve Justice lawsuit brought some equal protection claims, as well as claims that the issuance, if you will, of this 2017 guidance violated the Federal Administrative Procedure Act. In sum, the court denied, after a lot of procedural back and forth, the case ultimately made its way to cross motions for summary judgment. And what the court did is it denied the advocate's request for summary judgment and granted Secretary Devos's motion, finding that the 2017 guidance was not a final agency action. In that, the judge found that the 2017 guidance did not have any legal or legally enforceable consequences. And the way she arrived at that is that there were, according to a witness, an actual attorney from the US Department of Civil Rights, US DOJ, Office of Civil Rights, who submitted a declaration where he said that they would not be relying on the 2017 guidance to make any funding decisions about whether the Federal Department of Education should withhold, terminate, or terminate any federal funding to any school. So the court held that since this wasn't being relied on by the federal government for enforcement actions, and because there would be no financial consequences, that this was not a final agency action. What the court also was reading into the lack of finality was that in, I think it was in May or sometime in 2018, the Department of Education had also issued what's called a notice of proposed rulemaking, where it was telling everyone in the world that it was going to be promulgating an actual rule, a final rule to implement these changes as well. So on that, the court said, this is not a final agency action, and so I'm denying the advocate's motion. That occurred in the denial of the motions, of the advocate's motions, and the grant of Devos's occurred in November of 2019. The advocates appealed in December. And then 5 months later, after receiving more than 125,000 comments to the notice of proposed rulemaking, the Department of Education released its final rule on May 19th, with an effective date of August 14th, with the rationale being that they wanted to give schools a few months time to adjust and to implement the new final rule, but also to have the final rule effective date occur prior to the start of most academic years. So, and in essence, it's a very lengthy rule, but in essence, the final rule more or less adopted, and in some cases even went a little bit further in adopting the sort of the core approaches and themes of the 2017 guidance. So much of what you heard 2 weeks ago at the board meeting from survivors and their concerns about the federal agency approach is just as true, frankly, as it was under the 2017 guidance as it is under this new final rule. So not surprisingly, the final rule has spawned 4 lawsuits. And so I can stop now, or I can just go into the current status of those 4 other federal lawsuits challenging the final rule.
Thank you. Before, I would like to hear the status of the other lawsuits, but I just want to clarify and underscore. I heard you to say that the rulemaking was more or less complete and in May and effective in August, just a couple of months ago. Did I get that part right?
Yes, the new final rule issued on May 19, 2020, effective. Its effective date, August 14, 2020.
Thank you. Could you share a little bit about the 4 lawsuits and how that might or might not affect the existing rule? And also, let me just interject the question right now. You know, we obviously don't know the outcome of the election, but if there's a new administration in January, what does that suggest about the possibility of yet another change to the rule?
Yes, just to fast forward to answering that question. There are some restraints on federal agencies sort of going back and forth. There has to be a reason for the change in the rule. I suspect on this record that will not be too difficult for a new federal Department of Education to say, no, actually, we feel much more comfortable with the 2011 and 2014 guidance, and based upon the many comments, the 2017 guidance, and in turn the final rule, we're out of step. That can certainly happen, yeah, obviously it'll be a little bit different posture, and that does not require a change in federal law as it is a rule.
And presumably, Mr. President, that excuse me, a new administration could leave some portions of the current rule intact while amending others consistent with earlier rulemaking provisions. Yes?
Yes.
All right. And the 4 pieces of litigation and their relevance to this discussion?
Yes. So very briefly, there's 4 lawsuits, some of which have sought preliminary injunctions and not succeeded against enjoining the final rule, and 1 who has a trial, or that has a trial next week. So very quickly, the first lawsuit is called Know Your 9 versus Devos. This was filed in the District Court of Maryland. In this case, they made the same sort of Administrative Procedure Act challenges as was raised in Serve Justice. They didn't seek a preliminary injunction, however, and so this is going through the normal pleading challenges, a motion to dismiss by Devos specifically, and that is still pending. So no real action on that case. The more significant case is the case called New York versus U.S. Department of Education. This is brought in the Southern District of New York, filed shortly after the final rule was promulgated. They did seek a preliminary injunction, but unfortunately the court on August 9, so only 5 days before the effective date, it denied the request for a preliminary injunction in its entirety, finding in essence that while there were certainly arguments about a lot of the different provisions and the language used, that the court was giving great deference to the secretary in her interpretation of the statute.
Mr. Press, excuse the interruption. Could I ask anybody who's on the meeting to please mute yourself? Thanks. We're getting some back chatter there. Appreciate it. Go ahead, Mr. Press. Sorry for the interruption.
Thank you so much. Bottom line is I cannot detect that the parties to the New York case have yet filed an appeal, or if they have, I'm pretty sure that they have not secured a stay of that decision. So right now that injunction denial remains the order in that case. Although I am aware that the parties have filed cross motions for summary judgment, but the briefing is still going on through January of 2021. So frankly, no rescue from that lawsuit. The third lawsuit is called Pennsylvania versus Devos. This is filed in the District Court of the District of Columbia, filed frankly on the same date as the New York case in June. This is brought by 17 states, including the state of California and the District of Columbia. Brings the same APA equal protection claims. They also sought a preliminary injunction, and their preliminary injunction order issued only 4 days after the New York order. So it issued on August 12th. Unfortunately, the court there also denied the motion for a preliminary injunction, and its decision tracks the New York case very, very closely, and in fact, even cites to the New York district opinion in a couple of places. So those are pretty much in lockstep. And again, I cannot detect that there has been an appeal of that case filed yet, and certainly no stay of the denial of the preliminary injunction. So no relief from that case yet. The final case, which I would characterize as the last hope, at least in the near future, to enjoining the final rule, is a case called Victims' Rights Center versus Devos. This is filed out in the District Court of Massachusetts. Same claims, APA, equal protection. There, the plaintiffs also filed a motion for a preliminary injunction, and it was going to be heard on September 2nd. But on September 2nd, the court said, let's consolidate the motion for the preliminary injunction hearing with the trial on the merits, which is supposed to occur on October 14th. So next week, the trial of this case will actually begin. Not sure how long it's going to go, but that, as I said, is really the last chance that I'm aware of any lawsuit enjoining the rule in the near future.
Thank you. Mr. Press, notwithstanding the efforts at injunctive relief, what's your sense of how long this litigation could run? I mean, it strikes me that in many respects, we're at the early stages of litigation on all this, yes?
Yes. And I would add that while appeals of preliminary injunctions are entitled to essentially a more speedier resolution in the appellate courts, as I said, what was curious is that I cannot detect that the litigants in the Pennsylvania or New York cases have yet filed an appeal. And then depending on how procedurally it is treated in the Massachusetts case, the court could essentially dispense with the preliminary injunction aspect and simply make a final ruling on the merits. And whichever way that goes, that appeal could take a while. So bottom line is, barring some sort of extraordinary emergency litigation development, which I don't see happening, it doesn't seem like there's going to be any opportunity for much relief beyond this Massachusetts case, at least for the rest of this year.
And if the litigation continues, we could see a relatively long process, yes?
Correct.
Okay. Thank you. Anything else? I'll ask my staff, Mr. Press, to follow up with you on this issue in particular. So I just wanted to surface that in the meeting. Thank you. Anything else on our County Council verbal report?
That's all I have for the time being, unless you have any other questions.
No, thank you. Very, very helpful. And thank you for the focus on the particularly timely items. Let me go to the next item on our agenda, which is a verbal report from Prime Policy Group relating to the coming fiscal year and the federal budget process. I'll do that through Ms. Christian, and she'll introduce the Prime team. Before I do that, I did just want to make mention of the fact that I note that Tom Pike, the district director from Congressman Ro Khanna's office, is with us again, and so just wanted to acknowledge his presence and say thank you again to both Mr. Pike and Congressman Khanna for spending the time to be with us and hear our concerns. All right.
Thank you very much. Thank you.
All right. I think that takes us to item 7. Ms. Christian?
Yes, thank you very much. We've got 3 people from Prime Policy Group on the line with us. Marty Paoni, Rich Mead, and Aaron Dorton. They're going to provide information to you about the continuing resolution that was passed last week, what that includes and how long it goes through, and then a little bit of conversation about what different scenarios that could happen after the election. So with that, I'd like to hand it over to Aaron Dorton.
Thank you very much, Ms. Dorton. Good morning.
Hi, good morning. So my report this morning on the federal budget and appropriations process for FY21 will be brief and follow up to my report in early September. As you may recall, the House completed 10 out of 12 of its FY 2021 appropriations bills earlier in the summer. The Senate had not released their drafts or marked up any bills at the end as of the end of FY 2020. Therefore, a continuing resolution, or known as the CR, was passed and signed into law. The CR will end at the time of enactment of a full year appropriations bill or on December 11th, 2020, whichever comes first. In addition to continuing appropriations funding levels at FY 2020 levels, the CR contains some important additional provisions, as well as some flexibility for existing programs that are of interest to the county. I'll just go through and highlight a few of those so that we have a little bit of perspective. With respect to the small businesses, there are provisions which increase flexibility to process some SBA loans and the Small Business Investment Company, the SBIC, as well as SBA disaster loans, due mainly to increases in demand. With respect to transportation, there's provision which provides increased flexibilities by extending obligation deadlines for state, local, and tribal governments and other applicants who were awarded build grants in fiscal years 2017 and 2018. On a larger transportation scale, there is a division of the bill that contains provisions in the jurisdiction of the Committee on Transportation and Infrastructure, including a 1-year extension for surface transportation programs at fiscal year 2020 levels, as well as provisions shoring up the airport and airway trust fund. With respect to housing, the bill provides the Government National Mortgage Association with the authority to securitize a sharp increase in federal mortgages due to historically low mortgage rates. It also allows for the Department of Housing and Urban Development to obligate funding under the CR formula for housing for the elderly programs at a rate for operations necessary to maintain project rental assistance for the elderly and to continue the integrated wellness in supportive housing demonstration program, the I-WISH program. Lastly, and maybe most importantly for the county, as part of one of the last items negotiated in the effort surrounding the continuing resolution, the agriculture and nutrition sections of the CR restored money for farm payments supported by both Democrats and Republicans, and thus it also included funds for nutrition assistance programs, including a subsidized meal program for children who would normally receive meals in school. Specifically, the bill allows for several things. It allows for the Food and Nutrition Service to spend at a higher rate during the CR to both ensure the summer EBT program, the Electronic Benefit Transfer Program, to ensure that program is fully operational by May 2021, and to provide supplemental USDA foods to low-income seniors age 60 and over, and to some low-income women, infants, and children up to age 6. Additionally, the bill extends the pandemic EBT program, which provides resources to families with children who would have otherwise received free or reduced price meals in school, but for pandemic-related school closures or reduced attendance hours and this would extend through September 30th, 2021. It also expands the program to include children at child care centers affected by COVID-19 closures and reduced attendance hours. Additionally, in the same context, the bill extends nutrition waivers for the National School Lunch Program and the Special Supplemental Nutrition Program for Women, Infants, and Children's, known as WIC, that were included in the Families First Coronavirus Response Act through September 30th, 2021. And lastly, there's a section that extends the Supplemental Nutrition Assistance Program, SNAP waivers. It allows states to extend administrative flexibilities for SNAP through September 30th, 2021. The SNAP waivers extension section contains provisions that mirror Bill HR 7794, which was the Emergency SNAP Flexibilities Extension Act. And I note this as it was co-led by Representative Panetta. And the CR itself goes further than that, though, to extend the administrative flexibilities through September 30, 2021. In the healthcare section of the bill, lastly, which I know Mr. Margolin will cover in more depth, funding is extended for the Temporary Assistance for Needy Families Program, or TANF, and the Child Care Entitlement to States Program during the period of the continuing resolution. The extension will allow HHS to make first quarter payments to states. This is all I have for the moment. I believe my colleague, Mr. Mead, will add what I have left out.
Thank you, Ms. Dorton. Mr. Mead?
Thank you, Supervisor Smitty. I'll just add another key provision in the continuing resolution was that it included an extension of the 2014 Farm Bill hemp program. You may recall that in 2014, the Farm Bill allowed states to partner with institutions of higher education to develop hemp programs in their states. The 2018 Farm Bill took hemp off the controlled substance list and directed the USDA to establish a national regulatory framework for a hemp production program. The USDA issued an interim final rule last October, and the comment period on that rule was extended last winter for an additional 30 days and then reopened on September 8th for yet another 30 days. And the USDA opened the rule for comment because they're facing a lot of criticism for the IFR not being workable on a number of fronts. For starters, the THC levels in the rule were inconsistent with the THC levels allowed under the law. The timeline and methodology for testing were also problematic. USDA did back down from a requirement to have the testing done only at DEA labs, but these other problems remain barriers to this nascent industry. So the provision in the CER will allow states to decide whether they want to continue to operate on a 2014 Farm Bill pilot programs or operate under the interim final rule. And in talking to both the House and Senate Ag committees on a bipartisan basis, the thinking is by kicking the 2014 pilot program out till September 30th, 2021 will give USDA sufficient time to get that rule right so that the hemp industry can get going in earnest. I will turn to, and you mentioned this earlier, Supervisor, about the possible scenarios and next steps in terms of lame duck. And there's a lot of speculation that's going on in terms of what may or may not happen during the lame duck. I mean, certainly they've got to extend or resolve the appropriations issue for sure. They also have to extend all the what we call the health extenders, so preventing the cuts in the DISH program, for example, and graduate medical education and programs like that all need to be extended beyond December 11th. And finally, there's a desire to complete the National Defense Authorization Act. But there's, depending on the election outcomes, I think that will influence how much gets done during the lame duck session. There's some thinking that if the Democrats so-called sweep in the election, meaning Vice President Biden's elected president and the Democrats take the Senate, there's some thinking that they will defer all these issues into next year and just do short-term extensions of sort of everything and wait till they have full control of the Congress and have the presidency. There's also some who think that actually to the opposite, that if the Democrats sweep, they may want to get all this unfinished business finished so that the president's 100 days can be focused on his agenda and his priorities, not this sort of unfinished business. There's also some speculation that, perhaps under a, depending on the election outcome, one side or the other may be sort of so dispirited that they may not be willing to engage in negotiations. So there's a lot to be seen about what's going to happen in the lame duck, but I think we'll have a better sense of how that will shape up once we know the election results. And as you might imagine, there's some speculation too that we may not know election results on actual election day, that there may be some elections that may get contested or carry out with the requirement for counting all the mail-in and absentee ballots. So with that, I'll turn to my colleagues for any additional thoughts or comments they may have on the lame duck.
This is Erin Dorton. I would concur what my colleague noted, that I think that it could go any number of different ways when we get to the lame duck, as far as whether if the Democrats sweep, as he indicated, whether the Democrats are going to want to finish everything they have on their plate so that they can proceed with their new agenda starting in January, or whether they hold off on everything so that they can get it done when they have full control at that time.
Thank you. Ms. Dorton and Mr. Mead, I just want to check a couple of reference points. The lame duck activity, if any, would of course require both houses, yes?
That's correct.
Correct.
And to your point about timing, presumably a lame duck session would occur after the election, running how long in November, December in your expectation?
Our expectation is that the lame duck will convene the week of November 9th after elections. They will likely do what they call new member orientations. All the representatives and senators elect will come to Washington to get their office space, et cetera, et cetera. The next week being more of a legislative focused week is Thanksgiving. And so it only leaves another 2 full weeks before the resolution runs out. It's possible that the session would wrap up on December 11th with their work complete, but it's also possible they may need another week or week and a half extension to wrap things up and get done for the year. It's a little unclear how late it will go. In fact, at one point in time, there's talk when they're writing the continuing resolution, writing it to December 18th rather than December 11th, but they ultimately decided on December 11th. So we'll at least see probably two, maybe 3 weeks of session.
All right. Thank you both for that. Just an understanding of the timing is helpful as we try and determine at the county level when we might or might not have some clarity about outstanding issues. And Mr. Mead, two things. First is you are breaking up a little bit, so if there's anything you can do to help with the audio, that would be great. And the second is I can't help but tease you that the one substantive piece of business that you focused on was the need for members to select their new offices. So I'll just let that comment go out there in the ether. Mr. Paoni, I saw your square light up. Just wanted to make sure we hadn't overlooked you, sir.
No, that's fine. I concur with my colleagues, Erin and Rich, on their estimates and on their take on the lame duck.
All right.
Seems to be showcased on the Supreme Court nomination in the Senate.
Thank you. All right. Well, then I think what I'll do is say we'll consider the report received and with thanks, and move on to the report from Mr. Margolin on health matters. After we hear from Mr. Margolin, I'll ask the folks at Prime if they have any thing to share in the way of additional observations. If not, fine, but I certainly want to take advantage of the fact that we have a couple of teams of folks who are engaged on this. And then I'll look to the clerk, by the way, to keep me posted if we have members of the public who want to speak to any of these items. So again, thank you to the folks at Prime. Mr. Margolin, we're going to say you're up. Where do we stand in the ever-changing healthcare landscape?
Mr. Chair, excuse the interruption. We had a
Yes.
hand up for item number 7, public comment.
Well, thank you. Then I'll ask Mr. Margolin to hang on for just a moment. We'll go to our speaker who will have 2 minutes.
The next speaker is B. Beekman. I am unmuting you. Please accept the unmute and you will have 2 minutes to speak. The timer will start when you begin speaking.
Hi, I had a point, Blair Beekman here. I had a point of procedure that I hope you can restart the clock if possible. Can I have offer my public comment at the end of all the reports that are about to be given?
You certainly can. Would you like 2 minutes at that time, Mr. Beekman?
That would be great. Thank you.
All right, thank you for that. And we'll go back to Mr. Margolin, who keeps popping around on my screen. So thank you.
Thank you, Supervisor. Let me start by just adding to the very comprehensive report that Prime Policy provided on the CR by emphasizing that the dish cuts that the county has been contending with and concerned about.
Mr. Margolin, forgive me, if you could lean in and speak up just a little bit higher. I have you at maximum volume on my screen and you're still a little faint. Thank you.
I will do what I can to increase the volume of my end. So I wanted to just on the CR issue, which Prime Policy covered very comprehensively, indicate that on the dish cut deferral, it's an issue we've been tracking, big financial implications for the county. That was in fact, as Rich suggested, extended till December 11th, and we're paying close attention to the fate of that dish cut deferral. And there's also the one other issue, healthcare issue that I want to just mention is that federally qualified health centers, FQHCs, have also an extension of their funding. They're a so-called health extender program. There are several health funding programs that were going to expire, and the mandatory funding for FQHCs was one of them, and that's also extended in this CR package. Next item I want to touch on is the extension of the declaration of the public health emergency that Secretary Azar issued a few weeks ago. This is important to the county for many reasons. One of the key factors here is that emergency declaration is the rationale by which the county and others are allowed to bill for virtual care, telephonic care, telehealth care. That authority is carried through the emergency declaration. That was extended and for an additional several months. It also impacts the ability of California to get an enhanced FMAP, federal matching rate for the Medicaid program. That's worth billions of dollars to California, and that will also be extended for several additional months because of Secretary Azar's decision. There has been a debate at the state level about making virtual care reimbursement mandatory under state law because of a concern that at some point this emergency declaration process would fail California. The governor actually had bills on his desk to do that. The governor chose not to sign those bills because he wants his state health department to do a careful evaluation of how virtual care is being used, what works, what doesn't work before he makes any aspect of it permanent. So it's an issue, again, that's important to the Santa Clara health system, and it's one that we're continuing to track. Another key issue on which there was a major development is the proposed MFAR rule, the Medicaid Fiscal Accountability Rule that would have completely blown up the matching system for Medicaid here in California. Seema Verma, the CMS administrator, recently announced that they were deferring that rule. She was not going to pursue it any longer this year, not giving up on it totally, and I'll talk more about that in a moment, but backing away from the fast track that it was previously on. This happened as a result of a national coalition of multiple states working together to aggressively oppose the rule. California was part of that, but the lead in many respects was the state of Texas, a red state with a close relationship with the administration. This would have impacted them very negatively, and they played a very important role. One point that I would make about MFAR, though, and about which again deals with the issue of how states put up a match and what's eligible for match. This desire to clamp down on state matching and make it much more difficult for states to identify dollars for that purpose is really not just a Trump administration concern. It was something that was talked about in prior administrations, both Democratic and Republican. And no matter who wins the presidency in November, it's likely to be a continuing issue that we'll have to be concerned about, the MFAR matching, federal match issue, state match issue. Another issue that we should pay some attention to is there is a provider relief fund that has, over the last several months, in several tranches, provided large quantities of money for providers dealing with the COVID crisis. HHS just announced last week a new disbursement of $20 billion for provider relief. This is actually kind of a catch-all allocation designed to deal with providers who have previously not gotten their expenses covered and who feel they've been shortchanged. The criteria for accessing the money is somewhat vague at this point in time, but it is designed to deal with shortfalls that providers can document. Santa Clara County, I'm sure, will be pursuing dollars from this fund if, in fact, they have an appropriate case to make, and I'm sure they're evaluating that at this time. We talked, Prime Policy's already talked, and we all know, are aware of the fact that the COVID relief negotiations were taken off track yesterday by the president's tweet that he no longer wanted to see negotiations continue. He backed off that a little bit last night by putting out additional tweets saying that he was open to smaller bills dealing with the airline industry or dealing with relief for individual citizens, taxpayer checks. But Speaker Pelosi and the Democrats are quite concerned about a broad, comprehensive package being passed. It's unlikely that individual bills can survive this process. And it's unclear what the president's strategy here is. Mnuchin and Pelosi, according to most accounts, actually were making progress yesterday towards reaching a deal when the president, through his tweet, said he wanted to suspend all talks until after the election. So there's a small chance that things go back on track today, tomorrow, the next day. The odds are that we end up with no COVID relief, though, until after the election. On the 1115 waiver front, I just want to remind the committee that California has its request formally before CMS for a one-year extension of the 1115 waiver. This is the program that funds many things, but specifically the whole person care program that Santa Clara County has been a leader in implementing statewide would be at risk if this waiver extension was not granted. CMS says they won't provide an answer until the end of the year, December, maybe not till January, which takes us right up to the wire here because the waiver expires at the end of the year. The state Medicaid staff continue to be optimistic that they will get an approval for the one-year extension, but there is risk here. Notwithstanding their optimism, there is a chance this could be a problem for us before the year is over. The last issue I'd like to highlight is the issue that has by far the biggest impact on our whole healthcare delivery system if it goes the wrong direction, and that is the Texas litigation that is pending before the Supreme Court. So months ago, the Supreme Court said, we're going to hear the Texas litigation on November 10th. This is an appeal of the Fifth Circuit decision, which essentially said individual mandate without having a penalty attached to it. The penalty was the financial penalty was deleted in 2017 as part of tax reform, that without that financial penalty, it's not really a tax any longer, and it's therefore unconstitutional pursuant to earlier court decisions. That was the Fifth Circuit decision, validated also by the appellate panel. The big issue for the ACA, though, is, okay, what does that mean? California, in the case of the individual mandate being repealed, it implemented its own individual mandate, simply created a state law, and the rest of the ACA continued to operate. So the damage was minimized in California, and actually the damage nationally to people losing health coverage was less than most people expected. But the 20 Republican attorney generals who advanced this case, supported now by the Trump administration, are arguing, wait a second, if that's unconstitutional, the individual mandate, the whole law has to fall. Trump administration has qualified that a little bit in some of their recent arguments, but the attorney generals who are moving this case forward in the state of Texas, they want the whole law to fall. And that's what the trial court judge in the Fifth Circuit wanted to see done. So up until the death of Justice Ginsburg, well, this was a concern, and we've been talking about it, as you know, Mr. Chair, at prior meetings. The conventional wisdom among legal experts on both the conservative and liberal end of the spectrum has been that it was highly unlikely that this court with Justice Roberts and with Ginsburg there would repeal the ACA. Justice Roberts helped save the ACA in 2012 when it was originally challenged. The court in general, when it comes to the principle of severability, has had a somewhat conservative interpretation, which means if a portion of a law is ruled unconstitutional, you don't willy-nilly throw out the entire law if other aspects of it are in fact separate in how they operate and can logically be severed. So the, again, conservative and liberal perspective on severability has been, we need to respect congressional intent. Yes, provisions of complex national laws can be unconstitutional, but you don't take unconnected or loosely connected aspects of the law and strike them down as well. So in the case of the ACA, where again, based on this one piece being unconstitutional, the Fifth Circuit is saying the whole thing should be thrown out. You have the example of like the Medicaid expansion. So if it's no longer constitutional to force people to buy private health insurance, how does that lead to the Medicaid expansion, which has nothing to do with private health insurance and the mandate? How does that lead to that Medicaid expansion being viewed as unconstitutional? So conventional legal reasoning has been that it does not lead to that conclusion. And in fact, it's severable. And yes, you can do damage to the ACA with an adverse decision, but you shouldn't throw the whole law out. So that's been the conventional wisdom. Now with Justice Ginsburg's passing, and Justice Barrett now under consideration, someone who's been critical of Justice Roberts in the past and is viewed as an opponent potentially of the ACA, everyone is now concerned that a November 10th hearing could lead to, with a 6-3 conservative majority, even with severability and the precedent and conservative interpretation of severability, could lead to a bad outcome for the ACA. It definitely is at risk. I mean, again, even though conservative legal scholars I've spoken to have said, oh, there's no way, this is months ago, the court would strike this down. Judges in the Fifth Circuit who are conservative had a different view. They viewed it as capable of being struck down in its entirety. So depending upon whether Justice Barrett is confirmed, depending upon what Justice Roberts and Justice Kavanaugh have to say about this issue, they're the two other swing votes here. There is a risk to the ACA. It certainly will be an issue in the campaign in the closing weeks and a major issue in the confirmation hearings later this month. That completes my report, Mr. Chair, and happy to respond to any questions you might have.
Thank you. You covered a lot of ground, Mr. Murgo. A lot going on. I think it would be worth taking a moment, and if the folks from Prime want to weigh in, I think that would be helpful. If understanding there's a range of actions the court could take. So let's just sort of play this out. if the court said, you know what, absent the individual mandate, the entire ACA is no longer constitutionally sustainable, where does that leave us? So then what?
So again, it goes back to the scenario as to what happens with the election. If Biden is president and the Democrats control both houses of Congress, they would, I would assume they would work aggressively and quickly to repass the ACA and address whatever constitutional defects were identified in the court decision, and they would repass it. And they have the ability, either through the reconciliation process, where they passed it the first time with 51 votes, or through, if the filibuster were to be discarded, which is a possibility, they could somehow find a strategy for getting 51 votes in the Senate to repass it, and that's what they would probably do. If the Republicans retain control of the Senate, it's going to be a morass, and there'll be a law probably reenacted, but it will be a very challenging process. It's challenging even with Democratic control, because Democrats will fight amongst themselves and Republicans will weigh in. But if it's a divided government, it'll be very challenging. And if President Trump, of course, wins re-election, he has said multiple times, I've got a replacement plan. But as an example of what his approach has been, he signed an executive order a week or two ago, essentially saying, I'm taking care of pre-existing conditions with this executive order. Big flourish, big press conference. And the executive order he signed basically said it's the intent of the government that pre-existing conditions shall be preserved. It doesn't have any real operation of law. And if the court were to strike down the pre-existing condition protections, that executive order wouldn't save the day. So the president would have to work with the Congress to actually craft a new law. Now, in terms of timing, one more thing, even though no one can predict the court, given if the decision writing, I talked to some people expert in this field, know far more than I do about this, and their best guess is that the earliest we'd see a decision announced, although it could come earlier, would be March of next year. So one other thing to sort of factor in here is they may hear oral arguments in November. People will read the tea leaves and react to questions that are asked and how the dynamics play out, but we may not actually see a decision until March of next year.
All right, let me turn to the folks at Prime and see if they've got a crystal ball they want to look into and share some thoughts.
I'll just throw out that I agree with Bert. It would be a disaster if the court threw it out, because the chaos it would throw into the healthcare system would be unreal. And it would be something that Congress would try to put together, but it depends. Do the Democrats control both houses? And if nothing else, I think this would be an argument, a strong argument, if the Democrats do take the Senate back, that they need to lower the filibuster to a majority vote, because you can use reconciliation for parts of the program of the ACA that deals with federal revenue and outlays. A lot pre-existing conditions is not one of them, and that would not qualify under reconciliation. You have to put that in, and there are so much else in the healthcare law that would not be covered by reconciliation. And so this could be the impetus to lower the threshold on cloture, but we'll just have to wait and see.
All right. Well, lots to speculate about. Anything else, Ms. Christian or folks from Prime, on the healthcare report, which Mr. Margolin has delivered?
This is Danielle. No, I don't have anything else to add. Thank you.
All right, thank you. Then let's go on to item number 9, which is to receive another report from the folks at Prime relative primarily to the legislative and regulatory climate, and with particular emphasis on the issue that's already surfaced, which is where do we stand on negotiations about yet another COVID relief bill? Who'd like to begin there, Ms. Christian?
Thank you. This I'll start with some introductory comments. In your packet, you do have a written report that provides a brief overview of the past bills that have been signed into law to provide federal stimulus payments in response to the COVID pandemic. It also provides a broad overview of some what I would categorize as jumpstart efforts to enact a fifth bill. There's been news coverage last night. It seems like it's always evolving about where things currently stand, and I'm going to not provide any more information on that and ask Crime Policy to do that. But before they go in, Dr. Smith, did you want to say anything now, or did you want to wait until after Crime Policy Group provides its information?
Probably wait. My major concern is the effect that we'll have on the state budget. So
Okay.
I'll wait.
All right, thank you. And probably the most significant activity that's occurred is the House did pass a revised HEROES Act last week. So the House continues to get things moving, and the Senate just doesn't seem to be able to do the same. And with that, I'm going to ask Aaron Dorton to pick things up, or Rich Mead if she defers to him. Thank you.
All right.
Sure. I will go ahead and defer to Mr. Mead to kick us off.
Sounds like a double play combination, Dorton to Mead to Peony, but go ahead.
Well, on the, and Mr. Margolin made reference to this, the president sort of abruptly called off negotiations on the one hand. On the other hand, he sort of backtracked a little, number one. The number two, his chief of staff this morning said, oh no, we're still open to some discussions around this. So it's not entirely clear, where this is going. I will say earlier this week on Capitol Hill, we were hearing that bipartisan negotiations had begun in earnest at the committee levels in terms of trying to write this next new bill. But the president sort of mixed that all up with his tweets. So the path forward is not very clear. If I were to put odds on this, I think there's, maybe a less than 30% chance of something happening before the election, but I wouldn't say it's a 0% chance.
As you know, we have some significant state action pending, and Dr. Smith will correct me if my recollection is wrong, but I think for California, the key date is October the 15th. Is there any reason to believe, Mr. Mead or others at Prime, that anyone in Washington other than the California delegation is mindful of that date being important here in our state?
I think, with the speaker, obviously mindful of it, so I would think that she would make a push to try and conclude negotiations by that date. But again, she has to have the willing partners with the Senate and the White House too.
All right. So we're in a state of uncertainty yet again, and we'll know when we know. That's kind of the bottom line on all of it. Yes, not very satisfying, but that's where we are. Yeah.
That's correct.
All right. Any well, that was brief of necessity. Thank you. Anything else on this item, Ms. Christian?
No, I don't have anything else to add on this
All
item.
right. And the folks at Prime, anything else that wasn't covered in your prior report?
There's two other items that we thought we'd touch upon briefly.
Please.
One is, I was going to turn to Mr. Peony to give a little bit of a outlook in terms of the confirmation process for the nominee for the Supreme Court. And then there's one regulatory item that came out of the Department of Labor that I wanted to call your attention to as well. So I'll turn to Mr. Peony first.
Thank you.
Well, as you know, the Senator Graham has indicated, and McConnell, that they want to start their hearings on October 12th. They were right now planning on 4 days of hearings, Monday through Thursday. And that they have, last week it was announced that two of the members, Republican members of the committee, Senator Tillis, North Carolina, and Lee of Utah, had tested positive for COVID and are isolating themselves. Since then, Senator Tillis has indicated through spokesperson that he's feeling much better. He's recovered his taste and smell. They can, but I would expect them to not be in attendance for the hearings. Although for the hearings, as we noted a couple of weeks ago, where former FBI Director Comey testified, they can do the hearings by Zoom. And so they don't need to be present for the hearings. But when you want to report somebody out, the rule is that you have to be present. And so they cannot report someone out via Zoom. The reports are that Graham plans to try to announce and mark up on the 15th to report her out. Under the rules, a member of the committee may ask for a 1-week delay, and expecting that, he would then reschedule to the 22nd, the following Thursday. That would give 20 days for Lee and Tillis to recover, but of course the unknown is, does anyone else get sick in the meantime? We'll just have to wait and see. Fortunately, nobody's taking a trip to the White House lately, so they're avoiding that COVID hotbed. But if it comes out on the 22nd, if they do report her out on the 22nd, then Senator McConnell can go to her on Friday the 23rd, file cloture. I don't think he'd bring everybody in for the weekend. He could have a cloture vote on Monday, that following Monday, the 26th. Once you invoke cloture and it's only majority vote, there's 30 hours post-cloture for debate. Democrats would probably make some motions to postpone indefinitely or adjourn or try to slow the process down. But once he's filed cloture, that clock is automatic. You have the cloture vote 2 days later, and then if you invoke cloture, it's 30-hour cap. It's a very strict cap. And so while they can cause a fuss and make them cast some votes, maybe talk all night one night to get some press, that sort of thing. But at the moment, it looks like she is on her track to be confirmed that week of the 26th. And that's all we have at the moment.
All right, thank you for that. And presumably if that confirmation timeline played out as you've indicated you think is most likely, that would in fact put a new justice in position to hear the oral arguments in the Texas case, yes?
Correct, yes.
All right.
I just want to make sure everybody's aware that some people get confused as far as the vote count that is needed for cloture or majority vote. You'll see reporters write that they need 51. That is not true. You need 51 to be present to a vote. You need a quorum of 51. So if 90 vote, say, only 46 can invoke cloture, and only 46 would be necessary to confirm. So it's a majority vote of those present, a quorum being present. And so it's a sliding scale.
Got it. Thank you. And there was one other item, I think that Mr. Mead mentioned as being worthy of a couple more minutes here. Yes?
Yes, briefly. The Department of Labor issued a rule, a proposed regulation on September 22nd regarding independent contractor status. Since the 1950s, the Department of Labor has issued what we call sub-regulatory guidance to help employers determine who's an employee and who's an independent contractor. What they're proposing to do now is to wipe out all of that previous guidance and put into the Code of Federal Regulations some guidance in determining who's an independent contractor and who's an employee. And they've got a two-pronged economic reality test that says what's the nature of the degree of the worker's control over the work, and what's the worker's opportunity for profit or loss. And if both those indicators are going in the same direction, the status can be confirmed. If there's some uncertainty about it, they put out what we call 3 additional guideposts to look at the skill required to perform the job, the working relationship, the duration of the relationship with the employer, and whether or not the work is part of what they call an integrated unit of work. And those other three factors can be used in making a determination. I report on this because this rule is in somewhat stark contrast to the California law, AB 5 that was passed. And so, our expectation is, because it's inconsistent, when the Department of Labor does an audit around their regulation, assuming this goes into effect, it's likely that determination will get challenged in the courts, and this sort of adjudication between the California law and this federal regulation will have to get probably sorted out in the courts in all likelihood.
All right. Thank you. Another area of uncertainty then. One quick question, and I don't know if this goes to Prime or to Mr. Press and Mr. Mitra in our county counsel's office, or Mr. Margolin. I just wanted to get a minor clarification so I can follow the court case. At one point, I seem to remember it was Texas versus the United States. And then more recently, as I've been looking at the case or trying to follow, I see it as California versus Texas, Texas versus California. Could someone just provide clarity as to what the proper name of the case is and why it has morphed, if it has morphed, just so I understand the process? Thank you.
I'm happy to defer to Mr. Press, but my quick explanation for that is California took the lead in moving this issue to the Supreme Court for expedited review. The Fifth Circuit appellate court wanted to send it back down to the trial court for an additional analysis of what is severable, what can be preserved, what can't be preserved. That could have resulted in months, many more months of uncertainty about the future of the ACA. Attorney General Becerra and others said, no, we want the Supreme Court, this is months ago, to resolve this once and for all. And that's why it became a California versus Texas case.
So what was the Texas versus United States case is essentially the same case now by a different name at the Supreme Court, California versus Texas. Do I have that right?
That's my understanding, but I'm going to defer to Mr. Press if he has anything further he'd like.
All right. Mr. Press?
I don't know. I know the case that I had that went, or cases that I had that went to the Supreme Court, they also changed their names a few times as along the way. So that sounds correct, but I can certainly check on that.
All right. And Mr. Margolin, I'm just curious, in as much as California, among others, and I would put myself in this category, I did not want to see the Affordable Care Act struck down. I would have thought that the tactical or strategic approach would have been to say delay is our friend rather than sending it to the Supreme Court, understanding that calculation might have been different when the composition of the court was different prior to Justice Ginsburg's passing. But what do you have any understanding of what the thinking was in saying, from my perspective, it's let's put ourselves dramatically at risk sooner rather than later, which seems an odd calculation. I'm clearly missing something in the thinking that went into this decision.
So I'm not directly familiar, obviously, with the thinking of the Attorney General on this issue, but I had a similar reaction to yours when I heard that California was pressing for expedited review. But the argument that was made to me at that time by others following this case was they were so confident that the Supreme Court would would strike this down, would uphold the ACA, that they thought it was in the interest of the program to have certainty about the future, that this uncertainty was in and of itself destructive to the ACA, and it made people insecure about their access to health insurance. So that was the thinking, that with Ginsburg on the board, with Roberts there, this was not going to be overturned. Let's resolve this issue and provide the system overall with a degree of comfort that the law is in fact going to be preserved. That was the thinking at the time.
All right, thank you for that. Two more things before we wrap up, folks. One is just a reminder that as part of our consent calendar action today, we did take action to cancel the meeting, which had been scheduled on the regular day of the month for November 4th, next month, the day after Election Day. That seemed a poor choice for a couple of reasons. The more substantive of which is that we'd clearly have a better handle on the lay of the land and what the state of affairs was at the national level after the dust had settled, and we had a month to assess the situation. And then on an all too human note, a little hard to imagine that everybody was going to wake up bright-eyed and bushy-tailed and ready to go to work the following what could well be a long election night. So again, just to note that the meeting on November the 4th is canceled, and we have a meeting scheduled in that first week of December to sort out where we are and what the path ahead looks a bit like. And then turning to the clerk, I believe we have one member of the public who asked if instead of commenting on other items as we went, he could take a single 2 minutes at the end, and happy to accommodate that request. So let me just ask the clerk if that member of the public is still with us.
Yes, he is, Mr. Chair. I'll go ahead
All right.
and cue this up. The next speaker is B. Beekman. I am unmuting you. Please accept the unmute and you'll have 2 minutes to speak. The timer will start when you begin speaking.
Thank you.
Hi, thank you. Thank you for the meeting today. It was very informative. I hope the people who are here today, they can possibly go over a few of my own words from I spoke at about 10:30, half hour into today's meeting today. I feel at the state level, 3088 really left us short of what was really possible to be working on. And assembly persons like Ash Kalra and David Chu and others of the Bay Area, SF Bay Area, were really working on really meaningful yet simple ideas that could bring in, all parts of the community, the business community, the tenants of apartment owners themselves, apartments, small businesses together. A really interesting plan was developing, and it really hurts when those things can't be fully trusted. And what I tried to say in my earlier speeches, that I hope this fall can be a time that we can just simply learn to trust each other more and trust our good ideas that COVID will be done with in a few years. And in that meantime, I think there can be some really good ideas that can be of help to everyone. The current 3088 really cuts people out and sends people to the court system and sues each other and leaves people confused. And Ash Kalra was working, and David Chu was working on a system that was not doing that, that was leaving people open and happy, basically. So good luck on how to work on contentment. It can be possible. With my final, 6 seconds, thank you for what you talked about today. It's been a lot more progressive than at other meetings in the past year.
All right, we'll say thank you to all who were present today. Appreciate your participation. Clearly a lot of question marks that we're hoping will be answered in the coming months. And again, we are now scheduled with the cancellation of our November 4th meeting to reconvene the task force on Wednesday, December 2nd at 10 a.m. And we thank you again for your participation. Without objection, the meeting is adjourned. Be well.